Some of the key dates are as follows. Early voting for this election will take place here at Douglas County Courthouse beginning November 27th from 8:30 until 5 p.m. each day. The last day for early voting will be December 1st. November 27th is the last day to request an absentee ballot by mail for this runoff election. Finally, election day is December 5th. And Mirror Lake Elementary is the only election day polling location for this election. As a reminder, this election is only for those citizens of the Douglas County and the city of Villa Rica that live within the city limits. Next, we were made aware by one of the candidates seeking voter information for the current municipal election from the Secretary of State's website. We informed him that obtaining election information solely from the Secretary of State's website is ill-advised due to the fact that the state has acknowledged that it's still working on improvements of their system, its ability to produce accurate reporting information. In the future, we advise all voters to reach out to the local election office that are conducting elections for any election-related lists. Out of an abundance of caution, we did prepare mitigation methods for any individuals that did obtain an incorrect list for this municipal election. We had no reports of actual instances or having to use any of our mitigation techniques. This concludes office operations report at this time.
Thank you, Director Kidd. I have comment and question. So first, thank you all for the excellent work we did on election day, supporting the city of Douglasville and city of Villa Rica. And I think they are very appreciative of it as well. So thank you all. And thank you, Director Kidd and Deputy Green, for your leadership. And then secondly, the list you mentioned, is this like a voter list or election results? Or, okay.
Well, it's two parts to that. The individual in question first contacted our office because they obtained a municipal election list, but what they really obtained was a county voter list that was produced by the Secretary of State's website. The Secretary of State's office has acknowledged that the reporting mechanisms for Jarvis is not ready. They have acknowledged that they're working with their partners to fix that list. For municipalities, we actually use a municipal voter list. The municipal voter list is a list of individuals that live within a particular municipality, as well as their corresponding precincts. Prior to every election, we transmit the municipal voter list to the municipalities to which they verify our list. So our municipal voter list was correct. The individual candidate in question did go through the Secretary of State's website and not actually get a list from the county. We did inform him that the county has the correct list. This is also the same individual that had questions because they were obtaining election results information from the Secretary of State's website. It was later discovered that the Secretary of State's website was duplicating numbers for turnout. But the information that was present on Douglas County's website was correct and accurate for this municipal election.
Thank you for that clarity. Any additional questions?
I just have one. Those dates that you mentioned for early voting, any Saturdays in there?
The code section precludes a Saturday voting on election.
So no.
No saying that.
If there's some additional questions? Okay.
I just want to say thank you to the staff. I think they did an amazing job running the past election, fielding all the calls on the screen and the staff, down to everybody moving the machine in and out. Everything was very smooth. Over 2002, everything was very well. So I want to commend you all on the job well done. Thank you.
The next one is old business.
For old business, and you all have case tables, agenda item, it will require a vote by the board to untable this item.
Is there a second? It's been properly moved and seconded that we, discuss the September board meeting item. Are there any discussion? All in favor, say aye. Any negative? Hearing none, we move forward with the item. So is this in reference to the deceased list?
Yes, it says, in reference to the original deceased, list photo that was presented by William Ward into the office. Now, before we discuss the specifics of this list, we also have our legal counsel present in this meeting that did prepare, information that has been transmitted to this board about this deceased, voting process. So I will turn it over to Mr. Jonathan Yasi.
Good to see you all today, and also I have my colleague Leslie Susan is participating in the meeting remotely, so if she has anything to add, I'm sure she will. As you referred to, we sent around some findings to essentially lay out two pieces of information for the board. One, what are the board's legal options when dealing with voters who may be deceased, and two, what are some of the risks? And so hopefully this short memo sort of laid out those two pieces, and then that is what can inform your judgment. I can go over it, but it might be easier to answer any questions that the board has.
We don't mind this, to a high level summary, what you're saying.
I'd be happy to. So there are what we've identified as three legal avenues to deal with any voters who are believed to be deceased. The first is under OCGA 21-231D, and that's a process where in every county, the Register of Vital Statistics sends to the Secretary of State's office the list of people who have died. Secretary of State's office then sends out to each county elections, whoever the Register of Elections in the county, to remove those people from the list. This is the process that the board did not have a very active role in, but it is sort of I guess what we would term the sort of normal course of how this generally is handled. There are two other options for the board. The second one is under OCGA 21-231E1, and that lays out a way that if the board gets certain types of information indicating that someone may be deceased, can remove that person from the rolls. And I say certain types because the statute says exactly which types of information count. And I'll just make sure I have it here. It includes death certificates, obituaries published by local newspapers, verifiable knowledge of death, and information provided in writing and signed by a family member or family members of the deceased person. This is an area where, based on our research, we believe that some of those sources may be more reliable than others. And anytime there is any chance that a voter who is not deceased could be caught in the process, that would open you up to a due process challenge because under this section, there would be removal from the voter rolls before the person is notified. On the theory that if they're deceased, it doesn't matter, but there is risk there in case a name is incorrectly included in one of those sources.
Question number one before you move on, it leaves in my brain. So it's not specifically saying that you have to receive a certain number or types of source documents, right? It just says any of these documents. Is that, am I understanding that correctly?
Certainly not a certain number. When you say sort of any source, it would have to be one of the, well, it's a sort of very type, but it would have to be of the ones in statute, one of those categories. There's not a lot of established guidance on exactly what those categories mean. So for instance, when it says obituaries published by a local newspaper, there is not binding authority to say Does that mean local to Douglas County? Does that mean local to the place where the person may have died, if they're no longer in Douglas County? That is not clear. But it would have to be either one of the at least 4 verses laid out here, some of which are likely a little more reliable than others. For instance, you know, a writing signed by the family members probably carries less risk than Mr. Pickard. And so I'll briefly speak on the third option, which is under OCJ 21-228. The board has a generalized obligation to inquire into the eligibility of voters to remain on voter rolls. And so the board at any time can bring a challenge on its own to an individualized voter. And then there's a very specific procedure laid out for how to notify that person, put it on the agenda for a board meeting, and have them, you know, have an opportunity to be heard. Those are the due process protections, and then the board can take a vote on each individual voter under that. So that is something that can be done at any time. It could be done in conjunction with any of the other processes. For anything, without the board doing anything, the probate court should be sending monthly the lists of deceased persons to the Secretary of State's office if it turns out that the board knows that someone may have died and this process is going too slow or it's not working. The board can take it upon itself to have this sort of individualized hearing, which has the due process protections built in that should mitigate the risks of election.
Overview. So, Dr. Kidder, do you have any objections or feelings?
The only thing that I would ask the attorney to point out that they did highlight in their memo is, I know it was suggested before that the board did essentially want to take the action of individual hearings, that those most likely would not be able to be held in conjunction with our regular scheduled board meetings. They would have to be a separate scheduled hearing. That piece, we did, Mr. Abdallah is going to as well, the names of the individuals that were initially submitted to this board for review. We have identified the current status of the majority of the individuals, aside from 3 that have not essentially gone through or not currently going through a confirmation process. I would advise the board after hearing from legal counsel that the option of referring information to the vital records clerk and allowing the state process to continue to take place. Like our attorney just stated, the board has the option of sending notification to vital records and allowing those protections to remain in place. That would be my suggestion if this board does take action. We have identified of the initial list the names of 3 that have not started the confirmation process.
So the question on the 3 that's highlighted here, how did we receive these names?
These are the initial names that were submitted by board member Word to the office.
Okay. At this time, we need to take a vote on the recommendation from Director Kidd to send to vital records.
We have to before we use the vote. I would like to just summarize this
Oh, yeah, it's okay.
a little bit, just so that the board knows there's a lot of information that got put together by our staff.
Okay.
So I submitted the obituaries and the board put this together. So I would like to summarize this just for the board so that we understand what this is. We're gonna have a summary of a couple pages here for y'all. Actually, and I would like to add to the 331, 2123, and I'm gonna say this. None of what I'm about to say reflects anything negative on this staff in any way. This is about this law and how we're gonna follow it. And we kind of just glossed over the 231-231. We neglected to read section F, which says county registrar shall initiate appropriate action regarding the right to elect or remain on the list of qualified registered voters within 60 days after receipt of the information described in this code section. Failure to take such action may subject the registrar or the county governing authority for whom the registrars are acting to a fine by the state election board. So the failure to do nothing is not good for deceased voters once we know about them. So I want to say that. On this page here, I'm very confident that this is an intergovernmental communication issue. And I'm very confident that this happens quite a lot, and particularly when somebody's deceased or if they're on Social Security, they're checked out pretty quickly. So I know this does happen, and it can happen. The formal process of removing these voters off our election rolls is apparently not happening regularly, perhaps intermittently, as Director Field mentioned last year. I just set out to see how many deceased voters were on, or if they were on our rolls, and for how long. So what I am presenting to you is basically a summation of what all these papers say in the year that we were presented back in September. Director Kidd confirmed, obviously, that these are voters, and that's what this stack of papers showed. They were on our rolls, and most still are. The board has voted to table this item for the last two meetings, so today I'd like to just tell you about each person in there. The first one, Mr. RGA, died 5 years ago in Douglas County. In our Secretary of State system, we have a contact date of July 24, 2019, about a year after he passed away with a national change of address. His current status is active voter. So this is one of those breakdowns where the vital statistics didn't get from our county to the Secretary of State. You don't know. The last election he voted in was in 2016. Page 2 with me. Mr. JB, the next one, number 2, died 7 years, almost 8 years ago in 2015 in Douglasville. This was another breakdown from the county registrar or the state vital statistic to our Secretary of State that canceled the voter. His last election was November 4th, 2008, which was 15 years ago. In our system, we had a no clock start date of February 11th, 2016, and his current status is active, an active voter. Both the no contact and the NGE systems designed to move him from inactive or from active to inactive to canceled has not worked. And if he was alive today, he would be age 96. Mr. MFB, number 3, passed away almost 8 years ago as well, 2015. In Douglasville, same thing. Her current status is obviously active voter. Last election in 2000, which was 23 years ago. 22 years ago, 23 years ago. So this formal procedure to move her off the roll from the either the no contact or the 2 presidential elections hasn't worked yet either. Number 4, EMB passed 8 years, 6 months ago in 2015. This one was passed away in Maryland, Harford County. Obviously there's families still here, but out of state death, perhaps we can understand how the vital statistics may not have worked well. This mover should have been moved off the rolls after 2 presidential election cycles, and our rolls show our last vote was in 2012. 11 years ago, almost 3 election cycles ago. So the audit trail changed the status so that 9 years later, on September 13th, we have a no contact status change which occurred. She is currently inactive voter. If alive today, she would be 101. Number 5, Mrs. CEC, passed 4 years and 8 months ago. She was out of state in Oregon. Again, with the out of state process, we can understand how the biostatistics may not have gotten to our Secretary of State. Our rules accurately show her status canceled. And out of the 12, this was the only one that was canceled. Oddly enough, the cancellation reason shown is that her last vote was December of 2016, which was only one presidential election cycle ago. So I'm not sure how that happened with her. Number 6, this is ERJ, passed 7 years, 10 months ago in Carroll County. Voter rolls show we had the contact with her just a month after she passed. Not sure why that was. Regardless, this was a breakdown again with the registrars and biostatistics both at the state and county level. The formal procedure for the no contact or the NGE should have moved her off the rolls or at least the inactive. The last vote was 2012, 3 election cycles ago almost, and her current status is active voter. If alive, she would be age 96 today. Mr. RM, sadly only passed a year or 3 months ago in 2022. Last voted in 2012, 2 presidential election cycles ago. He would be 94 years old if alive today. His current status is active voter. Number 8, this is SFM, passed 8 years ago with an out-of-state death again. We'll expect that the biostatistics might fail, but we do have her inactive on our rolls, and her last vote was 2005, 4 election cycles ago. And she would be 94 if alive. Mrs. MAR passed away 7 years ago out of state in Tennessee. Our rolls certainly show her as inactive. Her last vote was in 2012, would be 96 if alive today. Number 10, BLR, passed 4 years and 9 months ago in Atlanta. Her last vote was in 2016. She would be 98 if alive. She's also an active voter. Mr. RES passed 11 years ago, a little over 2012 in Douglasville. Again, the biostatistics didn't get to our Secretary of State. And that last election was July of 2012, 11 years ago, currently inactive. If alive today, be 107. And lastly, Mr. RCU sadly passed away last Christmas in Nevada, out of state. Also inactive. Last vote was 2012, 11 years ago. If alive today, it would be 95. So that kind of summarizes what's in this packet. And from that, we can conclude the following items. 11 out of the 12 of these deceased citizens have remained on the voter rolls as active or inactive for a combined total of over 70 years. It's obvious that the formal process required by Code 21-231, our attorney just mentioned, to remove deceased voters off these rolls through the registrars of biostatistics is not happening. And I submit to you today, I'd like to find out why. The passive process is to remove the inactive voters off the roll, both with no contact and no bureau elections for 2 consecutive elections. Don't seem to be reliable methods, either based off of what I've seen. These passive processes allow them to remain on the rolls far over a decade, cannot be our vote for removal of deceased voters from our rolls. Finally, we must exercise our duty as a board to follow the law on behalf of the citizens of Douglas County to begin to remedy this issue of deceased voters not being removed from the rolls. We must remove the deceased voters off the rolls in a timely manner as the law intends. Lastly, the state legislature through the Georgia Election Code clearly authorizes this board to challenge any voters on the rolls, which we just discussed. It also gives registered voters in this county the same authority to bring forth any form of challenges that we might have to form. So therefore, I have some motions I would like to present for us.
Before you go into your motion, can I have my staff present something? Mr. Gonzalez, you did look at this today.
Yes, so what was passed out to you is around 2 p.m. according to George's My Voter page. You can go through those meetings. I believe he was just referencing and see their current status as of this meeting. 3 of them are active. The rest have been taught by the standard procedures and have been moved to either inactive or fixed. And I will add, yeah, with no input on our end beyond standard vital record, so with no coming back into
And the inactive status in this particular case means that it is going to enlist maintenance activities like Mr. Gonzalez just stated. The only ones that have not gone through any of the confirmation of the statuses of the 3 highlighted names. It is not the entire list, and this is the most accurate information, like you said, it has 2:48 p.m. today. I was not presented with the list that Board Member Word went through, so I cannot verify the information that was submitted in it as far as the cross-reference. But the packet that you have in front of you indicates the status of all of the individuals that are currently listed.
And this was what we had before, right?
The list is the same that you had before. This is this list that currently stands as of 2 p.m. today.
Yeah, okay.
So before you start with motions, I just wanted, so we know that this is not an intentional matter, right? And so we do know that communication, sometimes it's not shared in a timely manner from Secretary of State down to the registrars, because looking at the information you shared, sorry, that these folks are deceived, but at the same time, I'm glad that when you look at the time frame in which they voted, no one used their name or ID or anything to vote. So that is great. But on the second, but we do have to, I don't know, how do we be more proactive, right? I mean, you typically wait for the registrar. I mean, the Secretary of State sends you the information and you clear out your voter files. But in these cases, we're seeing several years pass, right? So it's our legal teams sharing with us today that if number 1 doesn't happen, which should be the most reliable way, but we see delays, are we going to go to 2 to 3?
Let me offer a little caveat. You all are seeing it as a delay. The confirmation process is not an instant process. It will always be I don't want to use the word delayed process, but it always has to go through specific steps. The reason why, even in the information Mr. Word presented before, of not seeing some individuals in
Excuse me, can you hear me?
I can hear you. I think we lost the feed in the boardroom.
That's not good. Just because I want to make sure I heard Member Word properly and what you said, Director Kidd, properly. So let me know when is a good time to ask my questions.
We can go into your questions.
So I want to make sure I understood properly that there are 3 remaining individuals who are still active and the rest of the 12 are now inactive. Is that correct?
Yes.
Okay. And then of the that are inactive, I'm sorry, of the 3 that are active, you said there was a distinction between one and then the 2 others. What was that distinction?
I don't think I made a distinction between those. We were just pointing out the fact that all the rest are in inactive status. The distinction I was making of the inactive status means that it's going through a confirmation process, but I was pointing out with the confirmation process, it was not intended to be a instantaneous process. It will always have a lag time with time between there. So it's not an instantly deleted from the voter roll with the inactive process.
Okay, and so there are 3 that are still active who are believed to be deceased. Is that right?
Yes.
Okay, and then in terms of the communication cycle here, is it a suggestion, and I wasn't sure what Member Word was saying, in terms of, is it the County Register of Vital Statistics or the Secretary of State's office or both? Not Douglas County, but the county, not the board registrar, but the County Registrar of Vital Statistics or the Secretary of State that where there's a communication, you believe, breakdown? Is it one or both, or you're not sure?
I'll answer that. So I'm going to answer it by reading the code and what it says shall be done. So in 21-2-231, subsection D, it says, unless otherwise notified by the Secretary of State, the local registrar of vital statistics of each county shall, on or before the 10th day of each month, prepare and transmit to the Secretary of State in a format prescribed by the Secretary of State a complete list of all persons, including addresses, ages, and other identifying information prescribed by the Secretary of State who died during the preceding calendar month in the county. The Secretary of State may, by agreement with the Commissioner of Public Health, obtain such information from the State Registrar of Vital Statistics. Additionally, the Secretary of State is authorized to obtain such list of deceased Georgia electors, if possible, from other states. So to answer your question, it's both county and state level that seem to not be transmitting their list that says that they're supposed to do for the preceding month of all deceased voters to the Secretary of State so that we can then clean our rolls appropriately. And so I would like to make a motion that we dive into this just a little bit with some freedom of information. So if I may, Matt?
So, we have 5 motions that are going to come forth from Board Member Ward. So, we can start, but I do see that some of this was in reference to county attorney directives. So if you all could provide us some feedback as we go through that, that would be helpful before we make a voting decision. So Chad, go ahead.
Okay. So I make my first motion that we have our county attorney submit a freedom of information request to the Douglas County Registrar of Vital Statistics to request the list of the deceased voters that they've made and transmitted to the Secretary of State for each month for the preceding year from October of 2022 through October of 2023, so that we can see if the list of deceased voters are getting transmitted by the county registrar as required by this code. The results of this freedom of information request shall be compiled and reported in a subsequent BOER meeting.
Well, there's a motion on the floor. Is there a second? Second. So probably moving second. Any discussion? And can the county attorney confirm, is this something we can do, or is this something?
So let me make sure I understand what, and I'm sorry that I'm on Zoom, and I'm may not be hearing everything that's coming across clearly. But Member Ward, the motion that you're making is to have the county attorney communicate with the County Register of Vital Statistics, basically the probate court, right? To ask the County Register of Vital Statistics to provide the list of what, the persons, the deceased persons who it has provided to the Secretary of State. Did I hear that right?
You did, as per this code, and I'm not sure that if it's the probate court or if it's the Board of Health. That may be one of the two, I'm not sure.
So what I would suggest, so I don't think it's the role of the county attorney to do that. And we can take it under advisement. So we can think about that and look at it and get back to you. But I'm thinking that it's something that the Board of Elections itself could request from the County Register of Vital Statistics. And were you saying every 3 months?
Every month, according to the statute.
No, I'm sorry. I understand that that's what the
Oh,
statute.
for the preceding year, 12 months.
So asking the County Register, the County Register of Vital Statistics once per year for every individual that they submitted to the Secretary of State as a deceased voter?
No, ma'am. Every month, they shall submit a list to the Secretary of State. We just want 12 lists for the 12 previous months.
Oh, I see what you're saying.
October of 22 to October of 23.
I understand. Yeah, I don't see, from my perspective, and I would have to take this under advisement on my end, but from my perspective, this is probably something that the Board of Elections itself can make the request to the County Register of Vital Statistics for that information.
I don't have a problem with that. So we can adjust the motion to
We're gonna read the motion for the BOER to submit FYI.
Sure.
Any additional?
This is Maurice. I hope you guys can hear me okay. If you can't, just let me know. But the question I have is this a request? Okay, so does the supervisor of the elections office get this information automatically from the Secretary of State that says we've got, these 5 people in the month of October of 2022 that are deceased or should be considered to be purged from our rolls? Is that information that we already get?
Yes.
I get a death report every month for the previous month from the probate.
Okay, so this is information we're already getting.
Yes.
Got it. Understand. Thank you.
So is this duplicative of, is seeking this information from the County Register of Vital Statistics on a monthly basis duplicative of what we already see?
That's why I wondered, is he asking for is this the same document? I already get a list every month from probate people that's just died in the county. They're not all people that we've identified as active voters. We have to literally go through the list, each and every one of them, and make sure that person is not registered. And if we find that they're registered, we decease them in our system. And if they're not a registered voter, we just move on. But I do get that list already every month.
So if we get the list every month, can we just share that in the meeting per month as an update?
That's something we can, because it has a lot of their information on it. Yeah.
So I just want to be clear about one thing. So I have several motions, but one is to check it at the county level of statistics and the state, and then have the Secretary of State send us the same records so we can see of the ones they've sent us and the ones they've received. Does this all match?
Tick and tie.
Tick and tie to make sure that where is there a breakdown in communication? So my subsequent motion that you'll see show that we're going to look for this at all levels. So the county, the state, and also from our Secretary of State to see where if we
Tick and tie.
And so with that, we have you can make a amended motion, we need a second on that.
I would second that with with the follow-up that what we're looking to do here is find the breakdown, right? That's ultimately
That's
what
what
we're
we're
trying
talking about.
So for the 5 motions we have here, we're gonna table this motion, that you just amended motion. Is it just possible for us to have this team circle back with us next meeting, or to share the communication they receive? And then from there, if it's, not up to par, then we can determine next steps after that. Because it sounds like they're already getting the information. We just have to, and you want to understand when they get to the Secretary of State, and then when it comes from.
Yeah, I want to vote, but my thing is, the words that came out last meeting were, it's not happening regularly. And I'd like to find out why. I'd like to find out from where.
Okay.
So, yes, we're gonna see the one that we get from the Secretary of State out of this. But we're gonna take a tie it to state and local level to see, are they getting this information sent to them on a monthly basis? This is what we need to know.
So for the first one, do you want to table or do you want to vote? Okay. And so repeat your amendment,
Sure. I make the first motion that we have our elections office submit a freedom of information request to the Douglas County Registrar of Vital Statistics to request the list of deceased voters that they have made and transmitted to the Secretary of State for each month from October of 2022 to October of 2023, so that we can see if the list of deceased voters are getting transmitted by the county registrar as required to the Secretary of State.
Is there a second?
Second.
Any discussion? All in favor say aye. Any nay? So we have, it's 3-2 and with names winning in this area. However, I do ask that the report is somehow, even if it's high level, summarized, that is shown to us in these meetings and provided to board members as soon as possible. The second one is.
The second one is very similar, that we have our Board of Elections office submit another freedom of information request to the Georgia State Registrar of Vital Statistics to request that same list of deceased persons from Douglas County that were transmitted to the Secretary of State for the same period, October of 2022 to October of 2023, so that we can verify the list of deceased voters are getting transmitted by the State Vital Statistics Office to the Secretary of State, and then this be reported to us in the subsequent meeting.
Is there a second? Any discussion? All in favor say aye. Any nay? Okay, so 3-2 here, similar situation here. Okay, next motion.
Okay, third one's similar. Freedom of information request to the Georgia Secretary of State to request all the list of deceased voters that we should have already been getting for the same period of vital statistics to remove from the Douglas County rolls. There are no files removed from the rolls October 2022 through October 2023 for the deceased voters as required by the Georgia Election Code 21-2-231. And it results in this to be reported in the subsequent meetings.
We have a motion, is there a second?
Second.
Any discussion? All in favor say aye. Any nays? 3-2 here again. The next, you have the fourth, and it's this. So the fourth motion.
Okay, so the fourth motion, we'll have our elections office send letters to these county registrar of vital statistics and state registrar of vital statistics and the Secretary of State outlining the concerns of this board about findings regarding deceased voters remaining on our rolls and the requirement in the Georgia Election Code 21-2-231, subsection D, subsection E, and D.1 and F do not appear to be happening based on this list. The target of these letters in fact finding and identify next steps to remedy this obviously broken process is required by the election code.
Is there a second? Any discussion? We have a question here. So the communication Director Kidd that you received via your team, CBC, it has a broken process, and it's something that we should bring to the attention of the Secretary of State.
I'll let you start.
Well, I would say that, other counties have already, we have generated a letter, not only to the state, but to the legislature about some of the, inconsistencies and things that we still feel are issues in the, system. The inconsistencies have never been also with receiving the notices monthly from probate. The thing is, in our previous system, we got our reports on the same day, almost monthly. So currently, while they're working in this system and they're still tweaking and perfecting or working on the current registration system, that there isn't a consistent time when things are not in the system, is what I'm saying. So we are getting information from the state. It's just, I can't say we get it on the 5th of every month, or we get it on the 10th of every month. It may be here today, I might not get anything next week, but then it may come on the following week versus monthly. So right now, as they're getting them, they're dumping them, and we're processing them as they come. So the consistency is, I can't tell you that they're going to be on the dashboard or on this particular day all the time. And I don't know if once they're finished, we're working on the system, whether it's gonna go back to a monthly though, or if it's gonna be consistent whenever they get it, it's just gonna be there, and that's something I'll just have to work every single day. But right now, so that's what we mean by inconsistent, but they are getting the information.
I will add what Deputy Director just stated. There has been a letter generated by the region directed to the Secretary of State's office highlighting the inconsistency of the reporting that we have already. The region that we are in the metro region of Region 3. This was the letter that was addressed the last meeting, which did contain subsections that referred to the reporting mechanism by which the state has acknowledged receipt of that and have indicated that they are continuing to work on this process. They have acknowledged as of today as well that they are bringing in a third-party vendor to begin to work on that consistency of the reporting mechanism. I do believe, in my professional opinion, that we're going to get the exact same response that we just got today, that they are bringing in a vendor, that they are aware of this issue and they are addressing this issue. But this board is free to act as it chooses.
And I would like to add just a reminder that none of the people that we've outlined here had anything to do with the current change of process. These are very old, go back 10, 12 years of people that have passed. And again, on the road for over 70 years for 12 people. So this is not working. Every time I've asked for a list, I haven't seen anything. So when I ask, is it happening? The answer is always intermittent. And so I'm concerned that the law that it says and how it should happen isn't. And I think it's incumbent upon us to find out why and correct it.
Any further discussions?
Well, I would just like to make a comparison, because 3 of the people you did call out were deceased in another state. And I guess it just so happened 3 of the people from this list is still active, and everyone else has been gone to active status. We haven't had a chance to cross-reference these, so that would be something that I would like. With these 3 active people, they have been 3 that died somewhere else. So, but other than that, you know, it's just, yeah.
There's no further discussion. All in favor, say aye.
Aye.
And nay. So it's, at this point, it's 3 yes, 2 no's. Okay, 5.
You say 3 yes, 2, and the other 3 were 3 no's, 2 yes.
I think you had 4 yes, Madam Chair. I was a yes, Madam Chair.
Okay, so it's 4 yes.
Okay, I didn't understand.
Oh, he
Or
said-
3 yes and 2
So
no.
it's 4 yes, 1 no. For member. So that motion passes. Based, based on the historical reference. And then
And then lastly, because the Georgia Election Code, section 21.2.231, subsection F, that I read earlier requires that the county registrar initiate appropriate act regarding the right of the elector to remain on the list of qualified registered voters within 60 days after receiving the information described in the code section of the Jackson County Code of Fine. I make my last motion to initiate formal action to remove any of the voters that are still active or inactive to cancel, using the formal voter challenge policy that was unanimously passed by our fellow board members last summer. For the requirements of subsection F, as for recommended by the attorney.
we have a motion, is there a second? In fact, moving a second in discussion. Now you have a question. Refresh our memories of what was passed last summer.
And that was the voter challenge. We, from the lawsuit that came out, we all came up with a policy to deal with challenges of both electors, and for, campaigns that come about. And that was what we needed for the past. We need to move.
Okay. Any further discussion? Okay, all in favor say aye. Well, if any nays, say nay. Nay. Okay. So with that, we already have so there's 3 no's, 2 yes. We already have a policy in place that we should follow. So is that correct, attorney?
I have a question on that process. So, as I understand, what the attorney is telling us is we actually have options, right? And we can follow. So we can either have a hearing, right? Send notification and have a hearing, or we can send the information to vital records and the vital records get. So I don't know if we need to distinguish between which one we should be.
Right.
Whichever is appropriate, I'm for, but doing nothing, I'm not.
So maybe we just do it, as it comes to us, right? So maybe we could just take the direction of those things, this direction to go. And you're referring only to the list you provided, or just in general? Just that list?
Just this list, right.
So.
If I understood Board Member Word, what he was talking about with the policy that was passed previously, those were for individual notice and hearing under OCGA 21.2.228. So that's what I understood the motion to have been about, and that the statute lays out the exact process to how to send notifications on notice and scheduling of the hearing, all those things, which would then put into the policy to make sure that we adhere to what's said in the statute. So that is one of the 3 avenues that I talked about today that we discussed. So that's what I understood the motion.
Okay. So for my character, so we pretty much have a process to follow for these 3 individuals, or
yes. So
okay.
So for that process, under 21.2.228 is in the individualized. So it's for any individual voter or candidate, and the board can choose to bring a challenge to an individual voter. My only recommendation would be if you want to follow that process, to have the vote for each challenge the board wants to bring. So individualized written voters that is included record if you are bringing a challenge to this voter, that voter, or different exactly who it is, and to follow if such a motion passes, then follow the process that I don't think that the board agrees with.
Okay.
And I agree with what Mr. Nussbaum just said in terms of if you're trying to follow 21-2-228 and challenge a particular voter, then you make the motion related to that particular voter.
Thank you, Bob. Is there any additional motions at this time?
I can read this one section here, E.1, which was referenced as part of the options. There's a couple options. So it says county registrars may obtain information about persons died from obituaries published by local newspapers, death certificates, verifiable knowledge of death, and information provided in writing and signed by a family member or member of the deceased person. County registrar shall determine if such deceased person's name appears on the list of electors, which we have, and if so, shall remove such name from the list of electors and shall send by first class mail to the mailing address shown in the elected voter registration records a notice of such action and the reason therefore.
That the motion, you want to follow to the letter to the family, or which way do you want to go with that?
Either way.
Okay.
And if I may, sorry, Madam Chair, so under 21-2-231E1, which board member were just referenced, that is an option if the information comes from one of the 4 specified sources. So for the board to take that action, just to make sure that the information is from one of those 4 specified sources. And to reiterate what was in the memo we sent around, this provision does allow for removal from the voter rolls before any notice is sent. And so just to reiterate that carries some risk that if there is a mistake, that can lead to litigation.
Right. Right. So we can just leave it with the 228
Follow the code.
policy
Yeah.
that we already have unanimously agreed.
Okay. Okay, sounds good. All right, so, okay, that's something attorney. Okay.
Right.
Thank you, board member Word. And our attorneys and director Peters for assistance with those matters that was brought before us. Next, we have new business.
Did you get the vote tally on that one? Number 5.
Yes, number 5 is 3 no's, 2 yes.
Number 5, 3 years, 2 years.
And next we have code of conduct and ethics, overview, which is new business. Will this be brought forth from our attorneys?
I'll start.
Okay.
The memorandum that you all received from the attorney, the first part of the memorandum does offer a little background information. This background information is from the governing legislation that organized this board, and I'll read it as follows. The board exercises the power and duty and responsibility of both the superintendent of elections and the board of registers for Douglas County. 2008 GA Law 3880 -1. The board is further authorized to organize itself, determine its protocol, rules, and regulations, adopt bylaw specifics, specify the functions and duties of its employees, and otherwise take such actions as appropriate to the management of the affairs committed into supervision. Such actions are permitted so long as they do not conflict with state law. A board and all boards of this county, for the most part, have some type of governing documents, and if you call it the code of conduct, the code of ethics, some type of governing document that lays out the duties and responsibilities of this board. All of this last year, we have taken it upon ourselves to formalize the processes of the Board of Elections and Registration. So this document that is before you is a document presenting options for organizing such a code of conduct for the Board of Elections as outlined by our attorneys. I will let our attorneys that have drafted this memorandum go forward now.
I think Director can lead it out well, that this memorandum presents some option for the board of here are areas where other boards have enacted some form of code of conduct. Some of it is about, some of it's ethics, some of it is workflow. These are just suggested areas where a lot of the examples that we have come from the Douglas County Board of Commissioners, their code of ethics pertains to the Board of Commissioners and not to this board. Others come from other jurisdictions around the state. So these are suggestions and examples of the types of provisions that could come together if the board wanted to pursue a code of conduct or code of ethics. If there are other areas of concern or areas of interest that the board wants to explore, we could bring in additional examples from other jurisdictions. But this memo lays out some of what I would say are common examples that other boards put into a list.
It was the intention of this board to present this document to you all today with the examples for you all to take back and review. Our attorneys have, like they said, given you examples that correspond to the Board of Commissioners. They've also given you possible language for the Board of Elections. My intention with this meeting was to present this document to you all and have you review it prior to the next meeting, and we will outline the specific provisions that will, at conclusion of a vote of the board, go into a code of conduct for the Board of Elections in our December meeting.
Yeah, just to follow up on that, the proposed language or the potential language in here is not ready to be voted on today. This is more to inform the board, to assist the board in discussing what it would like, and then we can finalize any possible language.
I have a question. So under staff work protocols, were there anything else in the code that referenced the administrative authority that the Director Kidd has versus the governance authority that we have as a board?
So let me make sure. So
we can understand under G.
yes.
So that we have a clear distinction of our responsibilities as well.
There's not any law or ordinance that would let out that specifically. There is a lot of discretion for the board to organize how the staff operates. And for that same reason, there's now an example from the Douglas County Board of Commissioners because it's a different body that would have its own internal operating. So that's why there are some examples. I think there's one example here from White County, for instance, that's one that we thought had parallels to the question that you have.
To add to that, too, though, not just with this document that's been presented to you, I also am an employee of Douglas County and therefore a contract employee of Douglas County. And there is specific language in my contract outlining the roles and responsibilities of myself as director. I would point you to addendum 1 of my contract, line 16, which says to administer and supervise the registration of electors of Douglas County. It also has me as to generally supervise, direct, control the administration of affairs of the Board of Elections and registration pursuant by law, and to duly adopt resolutions of the board. It also outlines that the administrative functions, the day-to-day administrative functions of the office are under my purview as the director as well.
Okay, but nothing that outlines the board responsibility. Nowhere in the code, I think, sharing that, nowhere in the code or anywhere. Okay. Any additional questions?
So how does this differ from bylaws?
And whoever wants to correct me, but I don't believe it does work.
You're asking, how is this different from bylaws?
You already have a bylaw.
Well, this is just a code of conduct that you can adopt, governing your own actions as members of this board. So this is a code of conduct that you can adopt. So it is distinct from bylaws. This code of conduct is not in the bylaws, or a code of conduct. Well, I shouldn't say that. I would have to go back and look at the bylaws to see exactly if there's any reference to conduct.
Leslie, I can catch that. There is no code of conduct that is currently in the Douglas County Board of Election bylaws. Like I said before, all of the other organized boards of Douglas County have adopted a formalized code of conduct for governing itself. That is one of the things that was previously missing from the Board of Elections. So this is an attempt to bring them in line with other boards that are currently being recognized by Douglas County, including the Board of Commissioners, which has both bylaws and a code of conduct. So this is essentially making this board a parallel function as well.
So just to kind of say it a different way of what I understand you saying is, it is standard practice to have a set of bylaws as well as a code of conduct document, if you will, that govern the board. Is that in my understanding?
Yes.
Okay. You have a question? I just have a question on, let's see what section this is. Section D, letter B, and then also section E, letter B. So they're somewhat similar about board representation and what the board represents themselves out, like to the community, as well as political parties, political advocacy groups. My concern here, maybe you guys can help me wrap my brain around this a little bit, is if you could kind of help me understand what we're trying to gain from this. Are we trying to say that if I'm out in the community and I can't represent myself as part of the Board of Elections and Registration, like what are we trying to achieve by this language?
So where we've seen this come up in other jurisdictions, it's an attempt to stop any individual member of a board, of whatever board that kind of adopted this, stop any individual member of the board from giving the impression that the entire board approves or has decided to take an action consistent with what that individual member does. So of course, individual board members are active in the community, are in contact with citizens, from, are hearing complaints and information and all sorts of things. It's this idea to proactively limit those members' ability to say that they have the authority of the entire board.
That could be one sentence thing, that's all we're trying to do. We don't need all this for that. There's a lot of vague items in here, terms that aren't defined. So, I've just read through it briefly. It looks a bit vague in some terms, in the potential language. For example, subsection or C subsection B, for paragraph, no board member shall disclose other than the council or county elected staff any information acquired during any session of the board that is closed to public listening. It is more of open meeting documents. Such disclosure specifically authorized by other board. And then the next one says no board member shall use any non-public information. So these are terms that need to be defined if we're going to go to this kind of level of control, trying to control even what they say. It's almost a violation of a person's free speech, as long as we're not disclosing things that are executive privilege or client attorney privilege. I think that's the intent. But trying to stop people from talking is not being too good.
But just let me just say that what this is just potential language, but it's really about what happens in executive session.
Right, that makes sense. I mean, we're just trying to protect the information that's private.
Yeah,
not
just
allow people to talk.
yeah. So what we can do, and as after we're done listening to the various comments, is I suggest that we hear from you specifically, and not just you, member board, but anybody and everybody about any point in here that you think should be more clear, or your question, or you don't like, or you want to change the wording. This is an opportunity for you as a board to look at the language, and it's an evolving process.
So do you recommend individuals email you, or just discussion for the next meeting?
My recommendation would be that any potential language or any potential issues that board members have, if they could send them to myself and my staff, we compile them and then confer with legal counsel and transmit to every other member a compiled list of any potential languages that you all would like to see.
Okay. So we'll have that directed. So anytime you have, we'll put a deadline on that so that you can have it for the meeting. So today's November 9th. If you can look at your, kind of get them in a week from today, following week of Thanksgiving, and then we got the following week, we're going into runoff. So a week from today, you can have your comments submitted to Director Kennedy and Director Green. That would be great. Okay. If there's no other discussion, are there any board member concerns at this time?
I just wanted to make a comment about the elections this week as well. One of the things I know, I made a comment about this on Tuesday evening, that in visiting the precincts, it seems that there was a lot of folks that showed up that thought that they could vote, but they were didn't reside in the city, they were county residents. And I just wanted to share with the elections team that, if there's anything that we could do to educate our people in the county a little bit better about, when you vote, what's a municipal election, what's a general, what's a primary, just some voter education, I think would be great. So I'd love to have some ideas, or hear what you guys think about how we can do that, so that we can sort of minimize that frustration for the people that live in the county to show up and find out that they're not having a good vote. So just wanted to do that.
Kind of feedback on something she said. A lot of people were upset that the look at them for sheriff's race and wasn't the sheriff's race, so they didn't vote at all. So
But some of them, they probably didn't vote, but they live in the county too. So.
that's what they told me.
Okay.
So I was like, it's just me voting.
Right.
They can do it.
Yeah. I got understand.
Let me add to that. I have sought legal advice from legal counsel as to action either this board or the board of commissioners could take to limit the time frame that county individuals have signage out before an actual county election, to which our attorneys have followed up. Y'all let our attorneys speak on what they found as far as limitations that the county can take as far as political signage and its limitations around it.
I will speak generally and say the First Amendment protections here are robust. And so it's very limited what this board or the board of commissioners could do to prevent someone putting up a sign to declare that they intend to be a candidate for an office. Leslie, you've looked at some of the specifics more than I have, but just to kind of set the stage for that it's going to be, if anything, very limited what we could do. And Leslie, if you have anything to add on that.
No, I don't have much to add on it, except to say that we really can't put up signs, and I think, Jonathan, you can speak to this because you know the general rule and why. But we can't put up signs without a First Amendment violation in the way that is being suggested.
And I'll elaborate a little bit on it. So the courts are particularly against anything that would be termed viewpoint discrimination. And the way that you can tell if something is viewpoint discrimination or not is you have to read the content to know whether the sign is allowed or not. And here, if you were talking about something that says, well, you know, put up a sign and you're proceeding, or you can say that, you have to read the content of the sign to know whether it's allowed or not. So that's going to get the highest form of scrutiny from the courts, which usually means those kinds of regulations are not upheld, and people's right to put up the signs, you know, really upheld. The things that the board could do, they often say that the sort of the share of speech is more speech. So the board can't affirmatively put up its own signage to inform voters sheriff's election not properly here or something like this. But in terms of limiting what a citizen can put out at their own signs, it's probably something.
Yeah, to touch bases again with that one, I did touch base with the city clerk because this issue has been raised to the city. We do agree that this is a voter education and outreach. It has been over 2 municipal election cycles before. We've had a complete citywide municipal election. We run into that. We also run into the fact that the municipality of Douglasville is located completely in Douglas County, so voters are confused between county and municipality. And we also have the parts of Douglasville that are unincorporated that are called in the county, and that confuses voters as well. One of my goals as the administration of the office is to actively engage a team to do voter education and outreach. And I have started sharing these plans with the municipality of Douglasville to consider too of adopting a voter outreach and coordination team during the municipal election, look at the means by which that municipality is disseminating information to voters. Being that this year is a municipal election, the municipality is charged with taking the lead on dissemination as it relates to municipal elections, but voter engagement and voter outreach are priorities of this current administration, and we were already discussing options for future elections, including municipal elections of our own signage as well. The attorney just stated that too, though, outlining that there are no county races, so we are going to combat speech with speech, and we're looking at mechanisms by which we can do that for future municipal elections.
The last comment, please, ma'am. The big answer of terrorism going on has been recent dialogue about thinking of things centered on the black reactions of the system. Are you prepared to accept input and calculate that?
Douglas County is in the unique position that we filter our mail and information that's transmitted to the elections office through the county's mail room. We have begun to transmit the information, but these are activities that are happening in the neighboring counties as it relates to mails being on high alert. I anticipate that the county is going to be discussing with the sheriff's office, which is responsible for security here at the courthouse where our mail room is located, and any possible steps that the county can take to be proactive. We're trying to head off those types of incidents. We are acutely aware of the current political climate, and we are taking those threats seriously.
Yes. starting over, last meeting, it was reported No Ink was a bit late in getting us the information for the electronic poll book used for in-person voting. And I want to know, have we followed up with this company either in writing, by phone call, and asked them for a next step in how they'll do better and make this so that it's not such a problem going forward into the next election cycle?
Okay. No Ink is the company that is responsible for the electronic poll book staff. This is a state-approved vendor that we have to work with at the county, dictated by the Secretary of State's office. When we did not receive our voter file in a timely fashion ahead of this past election, I did transmit email communication to the Secretary of State's office, Elections Director Blake Evans, as well as Michael Barnes, who is the Deputy State Elections Director responsible for systems, as to the fact that this is an undue hardship on Douglas County as it actively prepares for an election. I have asked for any mitigation techniques that the state plans to address with this vendor to be ready for this process going forward. I have, as of this meeting, received no response from the Secretary of State's office as to any mitigation techniques that they intend on filing with the vendor that we are required to use, and that we have no option of bypassing this vendor. If I do receive communication prior to the next meeting, I will transmit that to this board. But I share your frustration.
Okay, thank you. I just, my last concern is the ballot boxes for absentee votes that are around the county. What is the status of those? Where are we planning on doing with those?
The external ballot boxes that are around the county, there is a cover on those boxes. They're still precluded by law from accessing those ballots. When we initially put them in, we cemented them into the ground, as well as installed camera systems on those government facilities that they were encompassed in. So we were waiting to make sure that all legal action surrounding the passage of SB 202 had precluded before we went through the financial step of removing those boxes. I will have our legal team follow up with the state to make sure that if all legal action that is surrounding the passage of SB 202 has concluded, or where we are with any legal action that is currently surrounding the passage of that law. If we find that all legal action has concluded, then most likely we will take steps to remove the ballot boxes out of next year's budget. We don't currently have the funds to do so. We may have the money to allocate toward that project in next year's budget if we find that all legal actions are concluded.
Thank you.
Okay, thank you. Are there any additional concerns? Okay, so hearing that, our next regular board meeting is Thursday, December 14th at 5 p.m. And we will certify the municipal election Monday, November 13th at 5 p.m. All meeting details are on their website, celebratedouglascounty.com. And if there's no more business, we stay adjourned. May we have a motion? It's been properly moved and seconded. I'm sure no further discussion. Have a great